Thank you very much, Mr. Welsh. Adam Little.
Thank you. Good morning, Chief Justice, Justices. There are some who say that today's dissents are often tomorrow's majority decisions. The CLA submits that tomorrow has come. Justice Spence, in his compelling and well-reasoned dissent, was correct. The statutory requirements for demanding breast samples in what is now Section 254 sub 3 are preconditions to the Crown's reliance on the presumption in what is now Section 258 1C and the admissibility of the certificate under what is now Section 258 1G. In my brief time, I will attempt to make two submissions. One deals with statutory interpretation, and the other deals with the practical impact of overruling Rilling. The first issue that we'd like to talk about is, from the CLA's point of view, this entire appeal turns on what the phrase, taken pursuant to a demand, made under Section 254 sub 3 actually means. We say simply, this is an exercise in statutory interpretation. And to be clear, in our view, the fact that an accused could, and very often should, bring a motion to exclude evidence under the Charter, we say has nothing to do with correctly interpreting the meaning of this phrase. And again, I want to be clear. We do suggest that in most cases, a vigorous defense will involve filing a Charter application, because we know the only way to get the ultimate remedy of the exclusion of evidence involves filing a Charter application. But again, to come back to it, we say that has no bearing on the ultimate issue. At least it shouldn't. What I'd like to do is focus my submissions with statutory interpretation really on 2 points. And this flows from what the bench has said so far throughout the hearing. One would be the liberty issue raised by the Chief Justice, Justice Abella, and Justice Brown. And the other really will focus on the pursuant to aspect that was raised by the Chief Justice. I'd like to deal with the pursuant to part first. Like Justice Spence, we say that the most crucial words in the phrase actually are pursuant to. We know from this Court's jurisprudence that pursuant to is a restrictive term. Pursuant to means in compliance with or authorized by. And I apologize, my French is not great, but in the French version of the statute, I believe it's pronounced conformément à, which means in conformity with. We say that the use of this restrictive term illustrates Parliament's intention to limit the use of the presumptions to one very specific situation. The situation is where a demand has been made pursuant to Section 254 sub 3. The, difficulty or to respond to what the Chief Justice had raised really is this. Most of the cases have not considered the Rilling issue from a statutory interpretation point of view, which means this Court doesn't have that much guidance on what that phrase actually means. I would suggest, though, that the Court can consider two prior cases really from this Court. One, obviously, is the dissent in terms of what Justice Spence said. But the other is also what former Chief Justice Laskin said in Hogan. And if I can take the Court to Hogan, Hogan is contained in the CLA's condensed book. And the Court will find that, I believe it's at tab... It's at tab 7. And this is an older case. It actually predates Rilling by approximately a year. And if the Court goes to tab 7, it's page 51, we actually see what Chief Justice Laskin says, and we submit this supports our submission. He says towards the bottom part of the page in the paragraph that begins with, in my opinion, he says, strictly speaking, if the demand is made in conformity with Section 235(1), this satisfies Section 237(1)(c) and F. And we can also see the French translation in the paragraph right to its right is again the corps-maïfond, I said it wrong, corps-maïfond A, which again we say is in conformity with. We suggest that that supports the argument that really there is no ambiguity in this section. This section, we say, is crystal clear. It's put there by Parliament to clearly identify the one situation in which the presumption would apply. And that's when there's been a sample of breath that's been taken pursuant to a demand made under Section 258, my apologies, sample of breath taken pursuant to a demand made under Section 254 sub 3. We say that those words are limiting clauses. They're restrictive clauses. It's very clear in our respectful submission what Parliament intended. And if we go and we actually consider what Justice Spence says, Justice Spence, and if I could get the court to turn to Rilling itself, which is at tab 1 of our condensed book, and if the court goes to page 6, and it's the second paragraph of the page, the last sentence, Justice Spence makes clear from his point of view what is the most significant word, and it's because he italicizes it. He says, Parliament in express words made proof by the filing of a certificate in such cases possible only when the test was made pursuant to a demand under Section 235(1). There's a reason why he italicized those words. That's the key to the entire argument. And in our respectful submission, as I said, there is no ambiguity about it. And there's no ambiguity because Parliament used a very specific, very restrictive term. And again, we suggest the restrictive term is there for the intention of limiting.
You've used the term limiting.
Yes.
I thought another term that might be useful is a necessary antecedent.
It could be. The words could also be precondition, statutory requirement, ingredient. The list can go on. And while preparing for the hearing, we wrestled with the idea of what's the best way to actually put it. In support of our argument that it's meant to be restrictive or limiting, we suggest that if the court actually considers the construction of 258(1) itself, that actually supports our argument that there are some evidentiary provisions which Parliament intended to only apply in a limited set of circumstances and others that didn't. If I can get the court to turn to tab 11 of our condensed book, where Section 258(1) is produced. And if the court goes, it'll help to turn to page 62 of the book. My apologies, page 62 of tab 11. There the court can see 4 different evidentiary provisions. 258(1)E, F, F.1, and G. And the court will see that the first 3 can be contrasted to the last one. The first 3 do not have any limiting language, restrictive language, preconditions, requirements, such as, for example, taken pursuant to a demand made under Section 254 sub 3. The fourth, what we know, the section dealing with the admissibility of the certificate clearly does. We suggest that this confirms Parliament's intention that the presumptions in subsection C and G are only available when the breath samples have been taken pursuant to a demand made under Section 254 sub 3. And we suggest the court's entitled to compare and contrast, to look at and become aware of exactly what Parliament's intention is. Briefly, we think we need to respond to the issue that's been raised by the Attorney Generals with respect to the only requirements are ones that go to the scientific reliability of the evidence. And in our respectful submission, if that's correct, the logical extension is you don't even need a demand. And what I'd like to do is if I could take the court back to tab 1, which is Rilling itself, the court will see that on page 1, we've actually blacked out some of the wording. And if the Attorney Generals are right, they are asking this court to remove 8 words from the introductory phrase of what is now Section 258(1)C and G. And this is illustrated by looking, for example, at the top part where you can see subsection C. If they're right, the provision in issue at the time of Rilling would have read, where sample the breath of the accused has been taken. But that's not how it read. And Parliament specifically decided to put those words in there for a reason. And I note that my time is coming to an end very quickly. I would stress that it is a basic principle of statutory interpretation, and Justice Iacobucci has told us this in a case called Pickles. The court doesn't need to turn it up. It's at tab 5 of my book. But it's a basic principle of statutory interpretation that every word in a statute must be given a meaning. A construction which would leave without effect any part of the language of a statute will normally be rejected. And the submission really being made by the Crown, both of them, does that. It completely removes those words from the statute. And we say that's not the approach that should be taken by this court.
Parliament knows, though, how to use lawful demand and so on when they want to.
Yes?
many sections of the criminal code where they insert the word lawful,
Mm-hmm.
and it's not found here, right?
Yes, nor is the word valid. And we say that Parliament didn't need to go and say the word lawful or valid because of the specific language that's used.
Wouldn't they have made it a condition like B1, 2, and 3 if in fact that's what they really wanted? If they wanted to say, you know, that you can only get the presumption if the demand is lawfully taken, make it a condition. Make it part of 1, 2, and 3.
And we're
Add 1.
Sorry, we're suggesting that's actually what they did by using the words pursuant to a demand made under. The restrictive term links it not just to any demand, which Parliament could have done, but specifically to only one type of demand. So we suggest that in light of that, and I realize my time's up, we suggest that what Parliament is doing is they're in effect, without having to say valid or lawful, that's what they're doing. It'd be no different than saying, well, an essential element of the offense to a refusal is a valid demand, which we understand. The statute for 254 sub 5 doesn't say everyone who fails without reasonable excuse to comply with a valid demand, it just says to comply with a demand. And again, I realize my time is up. Subject to any questions? Yes.
There's a question.
One question. I'm wondering whether you think that sub 2 of 258 is a reflection of, or could be read as a reflection of Parliament's intent, that only where it's required under 254.3, namely where there's reasonable and probable grounds,
Yes.
that you can kind of, if it's not required, then you can't mention it in court. But if it is required, that is a reflection of Parliament's intent that you only need to do it if it is required, and required must mean if there are reasonable and probable grounds.
Yes, I agree with that. Or the other statutory requirements in 254 sub 3. Thank you.
The court will take its morning recess.